She was still talking when I picked up my pen. That's usually when people stop. When a judge reaches for a pen in a quiet courtroom, something shifts. The air changes. But Sandra Keller didn't notice, or maybe she did and just didn't care. Either way, she kept going. "And I want the record to reflect," she said, her voice cutting across the room like she was conducting a board meeting, "that this entire process has been a complete failure on the part of your staff, your probation officers, and frankly, your court." She gestured toward the prosecution table, then toward my clerk, then slowly toward me. I set the pen down. I've been on the bench for 19 years. I've had people cry in front of me, collapse, rage, plead. I've had a man throw a shoe. I had a woman faint, genuinely faint, when the foreperson stood to read the verdict. But in all those years, I had never had someone stand in front of me and point, not at the bailiff, not at the witness stand, at me. I want to tell you how we got here, because this case didn't start dramatic. It started routine, almost boring, and the worst ones always do. Sandra Keller, age 44, had come before my court on a third DUI charge, her second in 4 years. The prosecutor's office had pushed hard for felony charges. Her defense attorney, a quiet man named Douglas Parrish who had been practicing for 30 years and who knew how to read a room better than most, had negotiated her down to a misdemeanor with supervised probation. It was a good deal. Better than she deserved, honestly. But Douglas had argued, and argued well, that Sandra was not a violent offender, that she had no prior drug history, that her struggles were tied to a documented anxiety condition, and that treatment would serve the county better than incarceration. The prosecutor agreed. 12 months of supervised probation, monthly check-ins, mandatory outpatient counseling, and a breathalyzer device installed in her vehicle that she had to pass before the car would even start. Sandra stood right where she was standing now, and she said, clearly, without hesitation, "Yes, Your Honor, I understand." That was the last easy moment in this case. The first violation came at month 2, a missed counseling session. Her probation officer, Ray Cortez, 11 years with the county, thorough, professional, not the kind of man who files reports casually, submitted his documentation. Sandra's explanation was a work conflict. I noted it. I gave her a warning. The second violation came 6 weeks after that. The breathalyzer had flagged a failed startup test. Sandra disputed it. She sent a 3-page typed letter to my clerk arguing that the device was faulty, citing a manufacturer's recall notice from 2019. When my staff looked into it, the recall applied to a completely different model. I brought her in. I listened. I gave her a second warning and ordered twice-weekly random breath testing at the probation office in person. By month 7, Ray Cortez had filed 4 more reports, missed check-ins, failed tests. And then one night, a Tuesday, around 11 in the evening, Sandra called the probation office and left a voicemail. She was not calm. She named Ray by name. She named his supervisor. She mentioned the county commissioner. And she said, in a tone I can only describe as controlled but threatening, that she had options she hadn't yet chosen to exercise. Ray flagged the call immediately. I read the transcript myself twice. I scheduled a hearing. The morning it was supposed to happen, Sandra arrived without her attorney. Douglas Parrish was not the kind of man to miss court without a reason. When my clerk called his office, we were told that Sandra had terminated his representation 3 weeks prior, in writing, and had informed him she would be representing herself. I asked her directly, "Miss Keller, are you aware that you have a right to counsel in this proceeding?" "I'm aware," she said. "Do you wish to waive that right and proceed today without an attorney?" She looked at me the way someone looks at an automated phone system when they've already decided they're going to hang up. Patient, barely. "I've reviewed the relevant case law," she said. "I'm prepared." I had her sign the waiver. She read every word of it, actually read it, which most people don't. Then she signed it with a Mont Blanc pen she pulled from the inside pocket of her jacket. My court reporter glanced up at me for half a second. I kept my face still. For the first 40 minutes of that hearing, Sandra Keller was, and I'll give her this, technically effective. She had organized her documents in color-coded folders. She had a printed timeline. When she cross-examined Ray Cortez, her questions were pointed and specific. She challenged the timestamps on the breathalyzer logs. She questioned the chain of custody on one of the test results. And she raised a legitimate discrepancy in a check-in report, a 14-minute gap that Ray had, in fact, logged incorrectly. Ray corrected himself on the record. It was a small error. It didn't change the substance of the violations. But Sandra sat back in her chair when he admitted it, and she folded her hands on the table in a way that said, "I knew that." The prosecutor, A young woman named Avery Chen, 3 years with the county, composed in a way that takes most attorneys a decade to develop, leaned over and wrote something on her notepad. I couldn't see what it said. She didn't look worried. Then Sandra started making speeches. "Mr. Cortez has filed 6 reports on my case in 7 months, she said, standing without asking permission. For context, the average caseload in this office. I stopped her. "Miss Keller, you are not permitted to deliver statements during the officer's testimony. If you have questions, ask them. If you wish to testify, you will have that opportunity." She sat down, but she didn't stop. Small interruptions at first. A correction murmured under her breath. A quiet "that's not accurate" while Avery Chen was mid-sentence. I warned her twice. The second time she nodded, pressed her lips together, and then immediately said, "With respect, Your Honor, the officer's characterization is misleading." "Miss Keller." I kept my voice quiet. Quiet usually works. "One more interruption and I will hold you in contempt of this court." She nodded again. Then she waited 90 seconds and did it again. I called a 10-minute recess. When we came back, I asked Sandra if she wished to testify on her own behalf. She said yes. I reminded her she would be subject to cross-examination. She said she understood. The first few minutes she was measured. She described her work schedule. She described medical issues that had, she said, genuinely affected her ability to comply. She was articulate. She was prepared. There was a version of this where, if she had stopped there, things might have gone differently. But she didn't stop. She started talking about the system, about what she called a pattern of disproportionate enforcement. She named Ray Cortez again, not his professional conduct this time, but his motivations. She suggested, without quite saying it directly, that he had targeted her personally. She said she had done her own research on the probation office's reporting statistics, and that she intended to bring her findings to the County Oversight Board. Avery Chen stood for cross-examination. She placed a single document on the table in front of Sandra. 1 page. She didn't say anything yet, she just set it there. Sandra looked at it. For the first time all morning, she was quiet for longer than a breath. It was a printed transcript of the voicemail. The 11 o'clock call. The one where Sandra had named names and mentioned options she hadn't yet chosen to exercise. Avery read 3 lines of it aloud, slowly, without inflection. The courtroom was very still. I watched Sandra's posture change. Subtle, shoulders dropping maybe half an inch, jaw tightening slightly. But I've been watching people at tables for 19 years. I saw it. "Is that your voice on this recording?" Avery asked. Sandra said, "Yes." And at the time of this call, it was approximately 11:17 in the evening. I was upset. "That wasn't the question." Sandra looked at me. I don't know what she was looking for. I kept my face still. "Yes," she said quietly. "It was late." Avery Chen sat down. She didn't say anything else. She didn't need to. I let the silence sit for a moment. In a courtroom, silence is never empty. It has weight. It has direction. Everyone in that room was looking at Sandra Keller, and Sandra Keller was looking at the table. Then she looked up, and she started talking again. Which brings us back to where I started. The pointing. The statement about the court's failures. The voice that had gone from measured to something else entirely. Not angry exactly, but certain in a way that had come completely untethered from the room, from procedure, from the basic reality that she was the one sitting on the wrong side of a probation violation hearing. And I want the record to reflect that this entire process has been a complete failure on the part of your staff, your probation officers, and frankly, your court. I let her finish, every word. Then I said, "Are you done, Miss Keller?" She said yes. I said, "All right." And I picked up the pen. I found her in violation on 4 of the 6 counts. I dismissed 2, including the report with the 14-minute discrepancy. I gave her that. It was fair, and fairness is the whole point. On the remaining 4, I sentenced her to 60 days in the county jail. 30 of those days I suspended, contingent on her completing an inpatient treatment program and submitting to GPS monitoring for 6 months following her release. The other 30 days would begin immediately. I told her the treatment was not optional. The monitoring was not negotiable. And if she appeared before me again on a violation of these new terms, I would not be suspending any portion of the sentence. None of it. Sandra Keller sat very still while I read the order. She didn't interrupt. She didn't gesture. She held that Mont Blanc pen in both hands and she looked at the table, and for the first time since she had walked into my courtroom that morning, she looked like someone who understood exactly where she was. The bailiff stepped forward. Standard procedure. Sandra stood, gathered her color-coded folders and set them on the edge of the table, not handing them to anyone, just setting them down, as if someone might find a use for them later. She didn't say anything when they walked her out. I've thought about Sandra Keller a few times since that day. Not often, but sometimes. What I remember most is not the pointing or the voicemail or the pen. What I remember is the silence after Avery Chen sat down, that specific weighted silence. And the fact that Sandra looked directly at me in that moment, not at her notes, not at the prosecutor, not at the door. At me. She was looking for something, I'm not sure what, a way out. Or maybe just someone willing to look back. I looked back. That's all a judge can do. Then I picked up the pen and I did my job.